Just because you signed your trust doesn't mean your estate planning is done. A trust is only as good as what's titled into it, and if there's nothing in the trust, then the trust does nothing. Putting one's assets in their trust is called funding a trust. We have a few videos on this channel covering how to put various assets in trust and whether some more niche assets like collectibles and artwork should be in trust. But with the Thanksgiving holiday just a few days away, I'll let you get back to holiday planning with an overview of what assets should be in your trust. As we gather with family and consider what we're thankful for, I would be ever thankful for you showing your appreciation for what we do by liking this video and subscribing. Don't forget to ring the bell so you never miss a future upload. Our next few videos are going to be big and interesting, definitely something you won't want to miss. Let's start with a short explanation on what a trust is with an explanation I've used before. Picture a trust like a safety deposit box. You, the creator or settlor, place assets inside, and a trusted individual, known as the trustee, manages them. Over time, these assets can be distributed to people you designate, known as beneficiaries. The process of placing assets inside the safety deposit box is funding your trust, and primary reason to do so is because funding your trust with assets allows those assets, and thus your estate, to avoid probate. Again, probate is something I've talked extensively about on this channel, so I won't go into too much detail here. Suffice it to say, letting your estate pass through probate is a great way to allow fees to eat into your estate, causing a lot of headache in the family and guaranteeing nothing will be wrapped up in under a year of your passing. In California, there are two triggers for probate: any real estate regardless of the value, and a total estate value of $184,500 or more. Thus, with these two guiding principles, real estate or $184,500, we have our guidelines to determine what must be funded into your trust. Firstly, the easy class of assets that should be in your trust is real estate. Real estate titled in just your name alone or with another held as tenants in common will always require court involvement to some degree. The value of the land does not matter when it comes to determining whether we go to probate court or not. The value only tells us what route in court we go down, and we're likely on the most expensive and time-consuming route if the real property is worth over $61,000, which, with California's property values being what they are, then chances are we're going to be on the expensive path. Thus, with that in mind, all real estate, regardless of the value, must be funded into your trust by transferring title from you as an individual to you as trustee of your trust. That's about as close to a blanket rule as we're ever going to get. Next, let's talk cash and more simple financial assets. These are going to be your checking and savings account, high yield savings account, money market accounts, certificates of deposit or CDs, and annuities. For these assets, a general rule of thumb is that your checking account stays as is, as in your name alone, while the other accounts can go either way, but with a strong recommendation for anything earning some type of return, like interest, to be held in trust. Let's talk some numbers. As I've said before, the assets value limit for probate is $184,500. That is cumulative, not per account. To put it another way, between all of your accounts not in trust, if you add them all together, you cannot have more than $184,500 or else your estate will need to go to probate. Thus, when trying to figure what accounts should go into trust and which you should leave alone, it becomes very situation dependent and depends on what kind of numbers we're dealing with. As a general rule of thumb, for my clients, I tell them to take any accounts worth about $50,000 to $60,000 and transfer them into the name of their trust. That way, we can leave ourselves a lot of wiggle room and never approach the probate threshold, while allowing accounts that have earnings to earn while in the trust. Remember, accounts in trust don't count towards your estate when calculating whether we need to go to probate court or not. This basically amounts to any accounts above a normal savings account being titled into the name of your trust. The savings account can go either way. It depends on how much you keep in it, keeping in mind your checking account will also remain outside the trust. Very quickly, the reason I recommend leaving your normal checking account outside the trust is because 1, you typically don't keep too much in it, so no triggering probate, and 2, if it's in trust, then it makes it much harder for someone to help manage funds and pay bills on your behalf through your financial power of attorney. Typically, unless someone is also a trustee of a trust, they cannot have access to accounts held in that trust. Next, we'll talk about brokerage accounts, retirement accounts, and life insurances. These are generally much more complex and have their own rules to consider, so we won't go into too much detail today, but be sure to subscribe for more when we do those deep dives. Hint, hint. Brokerage and investment accounts should always be held in trust. These are accounts where you are typically going to have a good amount of value fluctuating and where you can see a lot of growth over time. Thus, it only makes sense to simply let the account grow in value in the trust, where we never have to worry about the value when it comes to probate. Worry about market fluctuations, not court fees. Retirement accounts like 401ks, 403bs, IRAs, and thrift savings plans are tax advantage retirement accounts that, if you have any plans to save for retirement, you should be utilizing one of these. It would frankly be silly not to. These accounts have their own rules and regulations that have changed relatively recently. Stay tuned for that information. Yet, we are likely going to tackle them all in a similar manner. You don't retitle the retirement account, you designate beneficiaries on them. Typically either by listing the people directly or by listing your trust as a beneficiary and allowing the funds to flow through the trust to the beneficiaries. However, there are some considerations for taking one path versus the other. What you must do, however, is pick someone to be the beneficiary. Because if you don't, then the account is part of your estate at death, and assuming you did enough savings, it will trigger probate. We'll do a deep dive into retirement accounts very soon, but to cover your bases here, it is generally a great idea to list your trust as the beneficiary, either the primary or contingent, so as to avoid the possibility of probate being required at your passing. Going further, the same holds true for life insurance. There will be less red tape and regulations when it comes to life insurance, but the general principle is the same. The money needs somewhere to go at your passing, otherwise it stays in your estate and will likely push it over the edge, requiring probate. This brings us to personal property. You generally aren't going to specifically reference personal property in your trust unless it's of great value, or you want to make it explicit from the start who you want to get your jewelry, for example. The reason is twofold. Number one, in practice, personal property generally isn't considered when it comes to totaling assets for probate unless it is of a particularly high value. And two, if you wanted to change what's to happen to those personal items, as in it must be sold or given to a specific person, then this sort of change requires an amendment to the trust, thus getting a lawyer involved and associated legal fees. Therefore, we typically recommend our clients not to discuss personal items in the trust itself and instead address it in a separate writing, what we call a letter of instruction. The trust will then reference this and require the terms of that writing to be incorporated into the trust as if it was written in there in the first place. Additionally, having a proper pour-over will ensures that all assets, including jewelry and cash, held in one's personal estate at death are to be poured over into their trust. This means that one's checking account would become a part of their trust estate, unless it's so valuable by itself it would trigger probate. Estate planning isn't for the wealthy. It's for anyone who wants control over their assets and peace of mind for their loved ones. However, no amount of money or success can take the place of time spent with your family. I'm attorney Andrew Bethel. Drop a comment below if you have any questions. Don't forget to like and subscribe and watch our other great videos. Have a happy Thanksgiving, and I'll see you next time.